around tax time for sure. But even after this, a lot of separated parents, divorced parents. What happens is one of the parents will take the deduction, claim the child, and then maybe file in February or March, and then typically it's the mother, but not always. Typically the mother will file, and then it'll be bounced back because someone has already claimed them. Or sometimes what will happen is that there'll be in a divorce settlement, they'll agree to alternate years for the deduction. So you get deduction one year, I get it the next, and that's the way it's supposed to work. But the IRS doesn't really adhere to the court order in these types of things, and so you should always make sure that this, not only is it in writing, right, in your divorce decree, but then you have these forms, and we're going to talk about that in just a minute. I'll show you the form that you should use for your spouse or former spouse or mother of your children or the father of your child, and the forms that you can release your claim as the custodial parent. So let's get to it, and we'll just first I want to review this with the IRS. Okay. Okay, so here we go. And here's the claiming a child as a dependent when parents are divorced, separated, or live apart. Again, one of the most common questions that I get. My spouse took it, my former husband took it on his tax return. How do I get it back? So first, I think before I read this, I will address for you what happens. So if someone has already claimed the child on their tax return, and then you claim it on you claim that same child on your tax return, the Social Security number you're using will trigger that someone has already used it. Use that Social Security number in a deduction. And so then the IRS will freeze, and then they'll ask both parties to prove who's entitled to it. And so that's really what happens. And that's, people get all irate about it and they don't know what to do. So let's dive into this. This is the press release. So IRS tax tip 2022-98, June 28th, so it was released yesterday. Parents who are divorced, separated, never married, or live apart and who share custody of a child with an ex-spouse or ex-partner need to understand the specific rules about who may be eligible to claim the child for tax purposes. This can make filing taxes easier for both parents and avoid errors that may lead to processing delays or costly tax mistakes. Again, if it triggers, you're not going to get your refund because they're saying you're not entitled to that. Someone's already taken it. And then it's going to take some time to work that out. And so again, if you have a refund due, you're not going to get it right away. This is the key here though, only one person may be eligible to claim the qualifying child as a dependent. Only one person, a child who meets the qualifying child rules. Parents can't share or split up the tax benefit for their child on their respective tax returns. So you don't split it. It's important that each parent understands who will claim their child on their tax return. If two people claim the same child on different tax return, it will slow down processing time while the IRS determines which parent's claim takes priority. So maybe we should talk about the qualifying child rule. So here's the test. There's a 5-part test to be a qualifying child. First, the child must be your son, daughter, stepchild, foster child, brother, sister, half-brother, half-sister, stepbrother, stepsister, or descendant of any of them. 2, the child must be under the age of 19 at the end of the year and younger than you or your spouse if filing jointly. B, under the age of 24 at the end of the year, a student and younger than you or your spouse if filing jointly. Or C, any age if permanently or totally disabled. 3, the child must have lived with you for more than half of the year. 4, the child must not have provided more than half of his or her own support for the year. 5, the child must not be filing a joint return for the year unless the joint return is filed only to claim a refund of withheld income tax or estimated tax paid. Excuse me. If the child meets the rules to be a qualifying child of more than one person, generally only one person can actually treat the child as a qualifying child. We just read that. Okay, so let's go back to that. I just wanted to, there is this 5-part test. Even something like this, right, gets very complicated with the IRS. There's lots of exceptions, a lot of tests on who's doing what, who qualifies, who doesn't, and it does get very complicated. But here's the big one now. Here's really what the rule is. Custodial parents generally claim the qualifying child as a dependent on their return. The custodial parent is the parent with whom the child lived for the greater number of nights during the year. The other parent is the non-custodial parent. In most cases, because of the residency test, another test, the custodial parent claims the child on their tax return. Again, what happens is a lot of people on their divorce decree, if they get divorced, have worked this out and say, well, again, the very common is alternate years. You take the even years, I get the odd years, and that's how they divide it. Now, if it's let's say it's the mother's year to take the deduction, she gets the even years, and it's the even year, and she takes a deduction, and the other parent, the father, files first and takes a deduction, or even files later and takes a deduction, there's going to be a problem. And when they're going to flag it, what's the court's not really going to, or the IRS is not really going to look to the court and say, what's your divorce decree say? They're going to look at this rule, custodial, who had custody. And if you have custody of your child, should be easy to prove, right? Who takes him to the doctor? Where did he live? Where does he go to school? All of that. And so it should be pretty straightforward to prove that you have custody of that child and the child lives with you more than half the year. And then if you could prove it, even if your divorce decree says that you're supposed to split it, the IRS will give it to the custodial parent. Now, the other parent then can get some relief through the courts because now you violated the court order, and there could be ramifications to that. But in court, not with the IRS. The custodial parent is the parent with whom the child lived. Okay, so tiebreaker rules may apply if the child is a qualifying child of more than one person. Although the child may meet the conditions to be a qualifying child of either parent, only one parent can actually claim the child as a qualifying child, provided the taxpayer is eligible. People should carefully read Publication 504, Divorce and Separated Individuals, to understand who is eligible to claim a qualifying child. Non-custodial parents may be eligible to claim a qualifying child. Special rules apply for a child to be treated as a qualifying child of a non-custodial parent. The custodial parent can release the dependency exemption and sign a written declaration or Form 8332. So again, and let's go. I have 8332 here. This is Form 8332. So here's the written declaration. So not only should you get it in the divorce decree that says we're going to, and this is how I've seen it, we're going to split, he's going to get alternate years, I get even, he gets odds, or whatever it is. In addition to that, let's go back to this. In addition to that, you should get a written declaration of such, that even numbered years. So whoever it is should sign a written declaration. So you should both have one. Actually, only the child generally has only one custodial parent. It's very rare that the child spends exactly the same amount of time in each household. That's rare. And so the custodial parent, if you've agreed and you're not the custodial parent, you should get a written declaration. And then every year, perhaps, get Form 8332, revocation of release of claim to exemption for child by custodial parent. Again, here is 8332. So you use the same form to revoke it. And so if you have a written declaration and you want to revoke it, you're entitled to do that. And the IRS will accept that revocation with this Form 8332. Again, you might be in violation of the court order, and the judge might be in contempt of court because you're not following the court's order. But the IRS will let you release the claim or revoke that release that you have. Again, might cause you some problems. But so if you are a non-custodial parent and you're trying to take the deduction, maybe again according to the court, you should get this 8332 release signed. I agree not to claim an exemption for the tax year, and so this is for the tax years. So you should get one of these while you're getting your tax return completed. You should get a release. This will make sure that it's everybody's on the same page. And that way, the release, if the other person claims it anyway, you have a release. The IRS has that release because you're going to attach it to your tax return, and it's signed. And so the IRS knows that you're entitled to that that deduction or tax credits, because there's more than just the deduction. There are tax credits and other benefits for having the child and getting those tax benefits. So there are some important things here. Let's just look at there's some examples. Let's look at special rule for children of divorced or separated parents. A child is treated as a qualifying child or a qualifying relative of the non-custodial parent if all of the following apply. The child received over half of his or her support for the year from one or both of the parents. If you receive payments under the Temporary Assistance for Needy Families program or other public assistance program, and you use the money to support the child, so it doesn't have to be your income. The child was in the custody of one or both of the parents for more than half of the year. Either of the following applies. The custodial parent agrees not to claim an exemption for the child by signing this form or a similar statement. Again, you can have a similar statement, not just this form. If the decree or agreement went into effect later than 1984 and before 2009. Again, they changed a lot of the rules there. They would look to the decree, but now they do not. A pre-1985 decree of divorce or separate maintenance of written separation agreement states that the non-custodial parent can claim the child as a dependent, but the non-custodial parent must provide at least $600 for the child support during the year. Not a large burden, right? It's not a big hurdle to jump over. This rule does not apply if the decree or agreement was changed after 1984. Well, you could still have a dependent child if they've been disabled from before 1984, but most are not, right? That's not most of this, so it's not going to apply to most people since 1984 was a long time ago. For the rule to apply, the parents must be one of the following: divorced or legally separated under a decree or divorce or maintenance, separate maintenance, separated under a written separation agreement, living apart at all times during the last 6 months of the year. If this rule applies and the other dependency tests in the instructions for your tax return are also met, the non-custodial parent can claim an exemption for the child. It's really about this form, right? So again, that's critical. This also applies to some tax benefits. Here it is, including the child tax credit, additional child tax credits, and credit for other dependents. It doesn't apply to other tax benefits such as earned income credits, dependent care credit, or head of household filing. So it doesn't affect those. So again, this is the most common question that I get, and so I wanted to address it here. Everybody has this question, and I wanted to address. They had a very good example of what if a 24-year-old is living with his younger brother and his wife, and they give him they support that, and he's a student, and they support him. Can he be a dependent? Well, the answer is no, because he's older than both of them. And so there's these rules. Again, it gets complicated, whenever it's not the norm, right? And you